All right, this meeting is being recorded by the City Council. If any other persons present are recording, you must notify the chairperson at this time.
I'm actually recording on behalf of the City Council. This is Danny from the Mayor's Office.
Thank you.
And Nick from GCTV, we are recording as well.
Right, but just the public portion, correct?
Sorry, yes, that's correct.
Thank you.
The council office will also be recording a separate recording of the executive session should the council vote to go into it.
Thank you. All right, with that, can I have a roll call of members, please?
Yes. Councillor Golub,
Here.
Vice President Gwynn, I don't believe is in attendance. I will come back. Councillor Disorder,
Here.
Councillor Bottomley emailed earlier. He will not be able to attend. Councillor Bullock,
Here.
President Gilmore,
Here.
Councillor Lapinski,
On the phone.
Councillor Mayo. I did not see that he was logged in, but I'm not sure, so I will come back to him. Councillor Healy,
Here.
Councillor Elmer,
Here.
Councillor Forgy,
Here.
Councillor Ricketts, Councillor Ricketts,
Present.
thank you. Councillor Toronzo,
Here.
Vice President Gwynn, I still do not see is logged in.
He's on vacation, Kathy.
Thank you. And I also do not see that Councillor Mayo is in attendance. Madam President, you have a quorum.
Thank you. Do I have a motion to suspend the rules of procedure?
So moved, Ricketts.
Second that. Toronzo, sorry.
Okay, and sorry, this is for to change the order and disposition of business. So we're gonna start with new business. We have a first reading. Councillor Forgy, would you please read for us?
President Gilmore? You need
Yes,
to take a vote to suspend the rules.
I'm sorry. All in favor of suspending the rules of procedure?
Aye.
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 Any opposed? Any abstentions? Okay, great. Sorry about that. All right, now if Councillor Forgy would please read for us. This is a Ways and Means item.
Okay, this is City Council first reading, August 31st, 2022. Appropriate $1,750,000 for the fire station. Rescind borrowing authorization for new library by $500,000. Appropriate $500,000 for fire station.
Thank you. And then there's a second one, right?
No, those
No.
are,
Sorry,
That's it.
no.
Those are the three.
All right. Next is motions, orders, and resolutions. So this is a vote to enter executive session. I'm sorry, do I need someone to make that motion?
I make a motion that we go in
wait, hold
executive
on just a
session.
moment, please.
Wait,
Councillor President Gilmore, you need to read item I under 5I on the agenda.
5I, sorry, let me get over there. Oh, is it on the last page there?
It is on the first and second page of the agenda.
I'd be happy to read it if that would help.
Are you talking about on the cover page where it says vote to enter executive session?
Yes.
Okay, I'm sorry, I was overthinking this. Okay. Vote to enter executive session for the purposes of hearing discussion of the reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss the discipline, or dismissal of, or complaints or charges brought against the public officer, employee, staff member, or individual. The individual to be discussed in such executive session shall be notified in writing by the public body at least 48 hours prior to the proposed executive session, provided, however, that notification may be waived upon written agreement of the parties.
Now a motion may be made if you wish.
I make a
make a
motion to
mo-
go into executive session. This is Ricketts.
I will second it. 4G.
Okay, all in favor?
Aye.
Aye.
Any
Could
opposed?
we?
I'm sorry, you asking for a roll call?
Yes. Yes.
That would be appropriate.
President Gilmore, once the vote is taken, the council will then be going into executive session. Would you like to announce whether the public body will be adjourning from executive session or whether the public body will reconvene from executive session?
I believe we will adjourn from executive session. We have nothing else on the agenda after this.
Thank you. A roll call of members. Counselor Golub,
Yes.
Counselor Disorder,
Yes.
Counselor Bullock,
Yes.
Counselor Lapiansky,
No.
Counselor Healy,
Yes.
Counselor Elmer,
Yes.
Counselor Forgy,
Yes.
Counselor Ricketts,
Yes.
Counselor Toronto.
Yes.
A majority of the counselors voted in favor. The motion passes.
Thank you.
I'm going to set up a breakout room, Council President Gilmore, and invite individuals. And once we're all in, I will lock the room. I'm sort of IT support. Does that work for everyone?
Perfect, thank you.
As long as I don't got to do nothing, I'm good.
Right. What do we have to do? Yeah.
You'll have to click the box to accept the
Okay.
invitation, I believe.
Correct.
What do I have to do on the phone?
I will take care of that. Councilor Lapiansky, I believe you'll just go over with the phone.
Okay, if I have to do something different, let me know. And if I get disconnected, who should I call?
You should call me, actually, Counselor, I have your phone number. I will call you if you get disconnected.
Thank you.
Okay,
Executive session was called at 6:12 PM.
all right, we're moving over.
Do we leave this one?
No, just stay put.
Hold tight.
Probably break it if I touch it, so I'm not gonna touch
Yeah,
it.
sorry, I'm looking at my list and making sure I don't forget anybody. Or put anybody in who couldn't go in. Okay,
Okay. Let's see it.
Click join.
I'm gonna stay over here until I see everybody.
Danny, I was invited. I don't know if you switched.
Yeah, I'll
me
get
up.
you in there. Chief, you gotta accept somehow. Unless you don't want to go in. And okay, that's me, and I'm going to lock this room. Breakout room.
If a counselor arrives late, can they get into the breakout room
Yeah, so I
by
can watch
invitation?
the other. I can watch the rooms in progress on my other screen, and if anybody joins in. Let's check. Counselor Lapinski, did you get over here okay? I see him.
Counselor Lapinski, can you hear us?
Yes, I can hear you. Thank you very much, Kathy.
Thank you. To confirm we have the same members of the council attending, would you like me just to do another roll call?
That would probably be the safest bet.
And on the second sheet that I emailed to you today, Sheila, there are a couple of notes. Would you like me to read them or would you like to read them?
Yeah, let me pull it up.
Okay.
The public body checklist?
Yeah, the second one that I emailed to you with the notes, handwritten notes on it.
That's not the one I have up. Give me a
Okay.
sec.
While you look, would you like me to take attendance?
Yes, please.
Okay. Counselor Golub,
Here.
Counselor Disorder,
I'm here.
Counselor Bullock,
I'm here.
President Gilmore,
Here.
Counselor Lapinski,
Or I'm on the phone, sorry.
thank you. Counselor Healy,
Here.
Counselor Elmer,
Here.
Counselor Forgy,
Here.
Counselor Ricketts,
Present.
and Counselor Toronto.
I'm here.
All right, so I have those notes.
Okay, so after the last bullet, it says once in exec sess,
Mm-hmm.
number 1 and 2, you should ask number 1. If you can read my handwriting, if not, I can read it, sorry.
Okay, so everybody in attendance must be by themselves. So we need to ask if there's anybody else who has someone else in the room with them. You'll have to find a place where you can be alone because this is going to be confidential. And I will say, I'm actually in the room with Ginny because I don't have privacy at my house. So that's my disclosure, but Ginny's allowed to be here.
Catherine,
Yes.
yeah.
I didn't realize that. My son is going to walk in the front door and into his room at some point, but he knows to leave me alone. Is that okay? Or should I go in my bedroom? He knows not to be in here and he won't be. He's 14. Is that allowed?
If you hear him coming in, would you let us know so that we can stop speaking for a moment?
Yeah, and I'm
And then-
also on headphones. And I'll lock so he can knock. So then we'll really know. Yeah, okay, I'll do that.
And full disclosure, I'm here alone right now with my 7-year-old, and she is downstairs on her TV. So I don't anticipate her coming up, but I will obviously let somebody know if she walks in. So
I also have a 7-year-old who's in we have an open concept downstairs, so 2 rooms away in the same room, but I'm also on headphones.
All right, great. All right, anyone else? I don't see any more hands.
I'm in City Hall with the ghost, so.
Okay.
Okay.
Me too.
And I'm in my home office.
All right.
Alone.
All right, and then next, so the mayor would like to make a statement, so I think now is probably the best time for that.
Oh, thank you, President Gilmore. Thank you, counselors, for being here this evening. I will try not to do this too often, but every now and then business needs to be discussed and done, sometimes in a special meeting. So I appreciate everyone being here this evening. Thank you. This executive session has been convened to discuss with the council and answer counselors' questions about an investigative report concerning Chief Haig and the findings of that investigative report, which specifically concerned the chief. As you know, the report addresses allegations concerning both Chief Haig and another officer in the police department. I want to make it clear at the outset that the purpose of this session today is not to consider any allegation or complaint against the other officer identified in the report. Rather, the purpose of this executive session is to review the findings in the report concerning Chief Haig and whether he engaged in any violation of law or other misconduct. In light of the specific purpose of this session and the strict limitations imposed by the open meeting law in these circumstances, we ask councilors not to consider at this session or inquire into any complaints or allegations concerning the other officer mentioned in the report. Attorney Dan Williams of Clifford and Kenny, who is here to discuss the report and its findings, he was the investigator, will not be answering any questions concerning allegations made against the other officer as discussed in the report. And thank you, President Gilmore.
Thank you. All right. So we're not going to talk about anybody who's not present. I think that's pretty clear. That wouldn't be fair anyways. And we're limiting it to just this investigation. So if there's anyone who would like to start with any questions or comments, I start with counselors. I can't see everyone on the screen, so if I don't.
I have a question.
Oh, yes, Counselor Elmer.
So I've read the document. This seems like a fairly narrow subject and a fairly narrow investigation in the context of a court ruling that had the town really upset. Do I have that right?
Somewhat. You know, I think it might be easier if I just kind of run through what we did for our investigation, and we can take questions at that point, if that is okay with everyone else.
Okay, but before we do that, I just wanted to see if counselors had any questions about, you know, kind of what we're focusing on here. Are we?
I did have one.
Yes. Oh, yes, Counselor Tronzo.
I was, I guess maybe more of a procedural thing. There was, between the couple of emails that I got, as they were considered confidential and we're, you know, saying we're only speaking, we're not speaking of the other person involved, who is named as, you know, person A, as it were. But then in other communications, it seemed to kind of disclose who person A was. So I didn't, maybe that was just a procedural thing about like which, or at least maybe I'm inferring who that would be. Just the way that some of the communications were written out was partially seemed to try to protect the identity, but then kind of other, whether it's through email or whatnot, expose the identity at the same time. So I just felt like that was a comment to make on whether, I don't know where that comes from or how it, where that line is drawn. But I just thought that should be noted.
Counselor Forte, did you want to respond to Counselor Tronzo?
Yeah, I actually wanted to ask the mayor a question if I could. I would like to know, in accordance with open meeting law, we are actually discussing a document which contains other parties. And they are mentioned by name. And so I would like to know if the other parties were invited to attend this meeting. And if not, why does that not violate open meeting law?
The other parties were not invited to attend this meeting because under the ruling, the rule number 1 for why you can go into an executive session it clearly states to discuss complaints or complaints against, I don't have the exact language in front of me, but I think certainly President Gilmore does, against an individual. And the meeting tonight is to discuss, one, to share this report. So naturally, the report does mention the other individual involved, but there's no way to avoid that. And you did receive also an executive summary as a short form for those of you who might not have had an opportunity to read the more lengthy investigative report before tonight. So that individual it was not invited. Tonight is to share with you the results of the report. I am doing that as a courtesy and out of respect for the council, because I believe you should know what it is. And then I felt like if it was important that if you had questions of Attorney Daniel Williams of Clifford and Kenny, excuse me, who did conduct the investigation, that you would have an opportunity to ask him directly about the investigation. Tonight, this is about Police Chief Haig and his status as an employee going forward following this investigation. It is not about the other individual at this time.
May I
Counselor
follow up? Oh, may I ask a follow-up?
Very quickly,
to the
can I just
mayor?
check with Counselor Toronzo and see if his question was answered?
No. I don't understand why yesterday we got a summary that included the other individual. And now I'm unclear on whether or not I'm supposed to be able to use that name in questioning, because yesterday it was open, and then today's final summary all of a sudden made the person, I forget how his name, person A.
So what I
out.
stated, I'm sorry, Counselor, I did not mean to cut you off.
No, it's fine.
Okay, what I stated in the opening statement was that the ground rules of this particular session are regarding the police chief, his employment status, and more importantly, the report that you have in front of you. As I said, I am sharing it with you. I think it's important that that report be, and I get the dichotomy that you are looking for, but it is important to limit this discussion this evening to your questions regarding the previous report or the executive summary. And I understand that you have asked that question. So that is where we're at this evening. I'm happy to stand back, and if you have other questions of me, fine. Daniel Williams is here tonight to assist you in explaining the report and answering any questions. Just keep it to the subject at hand this evening, and understand that you are in an executive session called for purpose number 1, which is an individual who has legal rights under this particular session.
I'm going to go back to Counselor Forgy because she had a follow-up, and I thought that the Counselor Toronzo's answer was going to be yes. So I'm sorry about that.
Again, this is for the mayor, follow up to the mayor. Who paid for this investigation and why was it ordered?
The city of Greenfield paid for this investigation, or will pay for it through their legal account. And it was ordered, as was clearly stated in both your executive summary and the more lengthy report itself. It was based on a conversation that was had in a parking lot outside of the court proceedings between Chief Haig and another police officer in the city of Greenfield. That conversation became the subject of a voir dire meeting between the presiding judge and the attorneys involved and the defendant, Robert Haig, and the police officer and his attorneys. All the attorneys, as far as I know, were present, and the defendant and the plaintiff were present.
But why was it ordered?
Because I felt it was important to get to the bottom of whether either individual, the other police officer, or Robert Haig, Police Chief Robert Haig, engaged in any conduct that was inappropriate given their official status.
Thank you, Mayor.
Okay, next I have Counselor Bullock, and then I have our Chief of Staff.
I'm a little stuck where Counselor Toronzo was, just as someone who recently did 2 open meeting law trainings. Mainly, I'm confused what the complaint was against the chief if we're not allowed to speak about the other party, especially in reading the investigation. It doesn't seem like there's a complaint against the chief. Is there a complaint that could be stated?
Mayor, if you don't want to field the question, I see 2 volunteers if you want to
The
choose your
attorney can
champion.
answer. I had my hand up because I thought I could sort of summarize and clarify for Counselor Toronzo, but I'll let Attorney Keston answer the legal question basically that Counselor Bullock has.
The issue was straightforward at the courthouse. 2 people testified under oath to diametrically opposite things. They could not be reconciled. So one of them was not telling the truth under oath. That's what we knew. One of them did not tell the truth under oath.
Okay. I'm assuming Counselor Toronto has a follow-up to that question.
Yeah, I also have a follow-up. Sorry, I'm still confused how we can speak about this without the other party present.
May I answer that? May I go? Because I think I can summarize it. President Gilmore, it's up to you.
Yeah, that would be fine. Let's see if that clears it up.
This is a summarizing of, after going over this for the last 2 days with the logistics of this meeting. This is a meeting that I know we're concentrating a bit on the report from Clifford and Kenny. The report from Clifford and Kenny, the reason for the investigation, and the reason why Chief Haig has been on administrative leave, and any moving forward of this individual employee of the city, he is the topic tonight. So the outcome of what this report means to the mayor and to the chief's employment and going forward is what this meeting is about. While the situation that the report was precipitated by does involve another police officer, that police officer is currently working, is not the discussion topic tonight. That's why this is about Chief Haig. I hope that's the way I understand it and the way I understand what we're doing tonight.
Can I ask
Okay,
one
Counselor Bullock.
Yeah, sorry. And then I'll let someone else move on. So am I inferring that this satisfies the requirement for an investigation to be done in order to bring the chief back into service to be a full reinstated as an employee of Greenfield? Is that the intent?
Should the mayor answer?
I think that is fair to say.
All right, Counselor Toronto had a follow-up.
I do. I gotta still say, like, I don't know, to use a modern pop reference, I just am not understanding the whole "we don't talk about Bruno" right now. Like, it's in the documents, it's there, but then all of a sudden we're all speaking about a person, regardless of whether that's the topic of conversation tonight or not. We're not even using the person's name, and it's in the executive memo.
Yeah, it
summary.
is not.
It's in the whole document, and
because that confidential document, you are allowed to know as a counselor, you are allowed to read it. We can't talk about it in this executive session because this is an executive session. They're 2 separate
isn't
things.
that still kind of confidential? Isn't that the point of the executive session, is because we're all have the same memos? We've all
Correct.
read the same memos. So
Correct.
why can't we talk about it openly? If that would be like all of us sitting around reading the same exact piece of paper that says confidential. Like we're in the war room. Like I'm just not understanding why it's a hang up.
It's
Because
because
the other person's not
there's
here.
two reasons. One, the purpose of tonight's meeting is to talk about the employment of Police Chief Haig, not the other employee. If there was another executive session to talk about some sort of action with that employee, we would. But because open meeting law is very clear that we shouldn't be having personnel discussions about personnel who are not here and not invited. And the reason they're not invited is because this meeting is about this one employee.
Right, well, I
Take
mean, wouldn't
away
it
chief, take away the titles, chief, whoever, whatever.
No, it wouldn't necessarily be like talking about their like personnel moves with them, but just being able to say the person's name as far as
We're
a
just-
reference.
Yeah, we're just being
So-
super careful.
Yeah, so
Yeah.
I would say that if somebody slips, this is a confidential meeting and no one should be talking about anything that happens during this executive session anyways. If somebody accidentally slips and says the name, I would be willing to just warn the person, forgive them and move on, but we're gonna make an effort to say employee A. Is that
Sure.
fair?
Yeah, I'm just thinking as a point of view from the chief of staff, where I have to supervise a lot of people. I have to have a lot of meetings about personnel issues. It is fair to make sure that individual is there when you're discussing something that actually affects their employment, but it doesn't mean you don't mention your colleague's name. If I'm having a conversation with somebody that I supervise and it's a matter of some sort of supervisory issue that I have to do some sort of reprimand, and we happen to mention another person's name, that's okay. But we're also not in an executive session of a council. But I think of it as that's my analogy. That's the only
Right.
way I was able to understand how this works too.
And President Gilmore, I do believe what you just said was fair. Is fair for how to proceed, because I think it's important that we do proceed.
All right, do we have any more questions specifically on this topic?
Yes.
Okay, Counselor DeSorger.
Okay, so my question, I would like to direct my question to the attorney. And I guess that could be either Attorney Keston or up there in the right. But I think your name with the white shirt and the nice tie is Attorney Williams. Is that right?
Yes, that's correct.
Okay. And I also only want to hear from the clerk on this, and so it is on this. So Attorney Keston, and either one of the attorneys can answer this because you're both attorneys, we're regular people. Two people, this is what you said, two people under oath told different stories, and they were diametrically opposed. So what you kind of indicated, one was telling the truth and one wasn't. This is with the two attorneys. So, and I want Kathy to listen too. So you're going to say tonight that one person was telling the truth, and you've thrown, no, or not. You're going to talk about whatever. Does this, you've read the open meeting law. I'm sure you're familiar with all the laws. We actually are talking about two people who were involved in something. Do you think this is right, that the other person was not invited? In the attorney's opinion, I want to know first. Both of you nice attorneys.
I can
can't
take
hear
this.
you.
I can take this first. Attorney Keston, you can pick up afterwards. But in terms of the open meeting law, as it's been discussed already, we are only limited to speaking about someone who's actually here and has been notified. So anyone else is, off the table, we can't discuss. And as the report and executive summary notes, yes, it arises out of, two employees discussing things, but the purpose of the meeting is really what dictates the scope of what we can discuss during this meeting.
You're muted.
Attorney Captain, you're muted.
Hi. So if I may, in any situation, the typical practice is you have a meeting about complaints and whatever regarding one employee, whether that employee's interactions with others. You could have a second meeting with the other employee if you want to discuss his situation, employee A. But this is the normal practice. So the normal practice for having under this exception to the open meeting law is to notify the employee whose complaints against whom you'll be discussing. And that's why this is going this way. It would be highly unusual to have the two of them, especially in this situation, to have both of them there. You're not there to adjudicate who's telling the truth, who isn't. I mean, that's up to eventually, I believe. I mean, we had an investigation. Eventually, the mayor has to make the call but that's why I have an investigator to see if you can get to the bottom of it. So that's how it works. That's how it almost always works. I've never seen a situation where you have two employees at odds who are in the same meeting to discuss the complaints about them, the two of them. So it's a bit awkward, but.
Thank you for that answer.
May I follow up? Because
Yes, and then I have.
I know I can see a lot of other hands up, but for the clerk, Kathy, and I'm sorry to put you on the spot, but you're the one that always keeps us, I'd say, on legal level ground here. This is an employee of the city, and wouldn't it be customary that the other person that's discussed all in something would, I'm just asking the clerk right now, okay? Would have been invited where he's talked about all through 6 pages of things. Just asking.
Okay. So from my perspective as clerk, this meeting was called by the mayor. She properly posted the meeting. She properly cited the executive session. She had legal assistance in determining the proper executive session to use and how to notify whatever employee that was to be invited. That was all done properly. And you all have the reports in front of you. I would not say it was customary to do anything when you have employees in this sort of situation. So I don't think there really is a customary. I think that this executive session was followed open meeting law, and the employees that were invited for the discussion tonight are the employees that are in attendance.
Thank you.
Next, I have Counselor Ricketts.
Okay, thank you so much. I just want to thank the lawyers, and I read everything before this meeting, and the person who shall not be named, I can see declined lots of this investigation. So I'm not actually sure why counselors have a lot of questions about why that person should be invited to begin with. So I just want to say that, you know, someone agreed to be part of this investigation and they sent us the results of it. And so I'm really ready to listen to the lawyers at this point and not keep going over and over why somebody's not invited, because they're not part of this today. If that person's name is part of an executive session in the future, then we'll talk about it then. But when you read the whole thing through, it's not even surprising to me at all. So I'm not sure what we're hung up on. And I hope that we could just move along and start to hear from legal counsel, because it's actually costing us money. So let's speak to the experts and, thank you.
Okay, but before we move on, I've got 3 counselors in the queue for questions. I have Counselor Elmer, then Counselor Toronto, then Counselor Bullock.
Counselor Golub.
And then I have, I'm sorry?
Counselor Golub was also in the queue with a hand up.
Oh, I'm sorry. So when you raise your hand electronically, it moves you up my screen so I can tell who did it first. So if people would hit that button, it helps me keep track. But Catherine Golub can go after Marion Bullock.
Do I have the floor? It's Phil.
Yes, please.
Yeah, I'd like to follow up on Councilor Bullock's question, which the mayor answered in the affirmative, that this is a process to reinstate Chief Hague. I'm still stuck on the fact that in 2015, Patrick Buchanan sued me.
That is outside the scope of this executive session. That is not a topic for this night.
Okay, I would like just to register that that not having it be a topic here makes this as a path to reinstatement seem illegitimate, and that's all I have to say.
Okay, next I have Councilor Toronto, then
I was
Bullock,
al-
then Golub.
I was also kind of following up on Councilor Bullock's question. So are we to understand that the purpose of the administrative leave so far has been because of this investigation as to what happened outside the courtroom, as opposed to the verdict of what happened in the courtroom?
That is 100%. I'm sorry, Sheila, I will answer that because
Yes, please do.
it will help us move along. Yes, that is 100% true. The investigation was called, and I think that was very clearly stated in both reports regarding the out of courtroom discussion that occurred between Chief Hague and the other police officer. So you are correct. It is not relative at this time or even at during the session to the court case at hand. It was outside of the court, but important enough to be concerning and important enough to warrant an independent investigation. And it is why both officers were put on paid administrative leave. One of them, as Chief of Staff Letourneau said, is back to work, and the other one is pending the investigation. You have the results of the investigation in front of you, and that is the subject of the meeting tonight. And you have Clifford and Kenny, Daniel Williams of Clifford and Kenny here as a resource for you.
Could I follow up with that, Councilor?
Yeah. Go ahead.
So if we're just getting the results of the investigation now, but one was returned to duty earlier than the conclusion of the investigation, I guess that's where the difference is I was not under the impression that this was the cause of administrative leave. I guess it makes a lot more sense now. But if we were waiting for this conclusion to come out for one employee to be returned and not for the other, I would either neither or both have been at the same time is kind of that seems kind of weird, if that makes sense.
I will not answer that because it borders on the breaching the reason for this meeting tonight.
Ask it later, separate.
Okay.
All right, next I have Councilor Bullock.
And then Councilor Lapiensky.
Well, then Councilor Golub and then Lapiensky.
Golub is next. Councilor Golub. Sorry.
Yes, I think that I'm trying to think how to word this within the scope, but Councilor Toronto followed up with the sentiments that I have here, and I just want to echo what what Counselor Elmer said, probably not as eloquently, but if this investigation is the path to return Chief Haig to work, it seems sketchy at best. That we did not follow similar pathways for other employees, and that it was not clear from the onset why our chief of police was on leave.
I think we tried to tell you in the previous executive session, but it had this same kind of feel. That was the purpose of that. Sorry, I'm out of order, but
It's never clear.
we tried to tell you guys there was a reason why everybody was going on paid administrative leave when they did. And it wasn't because of a verdict from any court case. It was because of another situation.
That was
My
never made clear.
understanding of the last executive session was to talk about the next steps for the.
Yep.
Oh, okay. Maybe
yeah.
that's what wasn't what it was, but
Yeah. So I just feel like I need to echo that. I think myself as a counselor and the general public is under the assumption that our chief of police has been on leave because of the verdict from a court case, and not from a separate situation. And this investigation, which is questionable to me by like who chose these people. There's a lot of questions I have. We'll get to, I'm sure, but I'm confused why one employee has one set of standards and the other doesn't.
the chief of police was put on leave, paid administrative leave at a date in the past because of the situation that happened that this investigation outlines. In that is 100% true. And as far as the general public and the council being confused, I noticed, but we have not told anyone anything different the entire time. It is very complicated. And I know when I've talked to individuals on this council, I have said to you individually how complicated everything is. And this is the reason why 2 employees were put on paid administrative leave. I know we're not supposed to talk about the other person, but there are other reasons why that person was brought back to work that were workload
That is
related.
outside the scope of this executive session.
Thank you.
I just, this is my last comment. I just want to say that I understand that this is complex, and I don't think it would, like, I think it could have been clearly stated to the council at any point. Our chief of police is on leave because of a separate situation that is related to the trial, but is not because of the verdict. And I don't think that's complicated. And so I just feel like I need to state, a lot of times I feel like the response we get from the city and from the executive side is like, things are really complicated. Like, we're all very smart people here. And so we can understand complex things.
I will happily find you the memos and written information that says the exact reason why he was put on leave. I'm certain it was put out in writing. The reason I mentioned the complicated is not because I'm trying to sound confusing. I'm not trying to run interference or be condescending or anything. It's because it is, because I recognize how confusing it is that this one big thing happened and then this other less big but also big thing happened, and that's the reason why people are being reprimanded in their jobs. And I'm trying to look at it from a personnel standpoint. That is the reason why this was the way it was. But I'm certain that it was written in clear language somewhere in writing, and I'd be happy to find it at another point.
So I'm going to hit pause before we go back to questions. I do remember that we were told that the chief was going to be out on paid admin leave and it was not related to the verdict. And I think that, you know, the feeling in town was, oh, what a coincidence. Of course, it's related to the verdict. And that feeling sort of persisted, and it's been a few months. So I understand the confusion there, but I do remember seeing something in writing that it wasn't related to the verdict. So now this makes a little bit more sense. And Councilor Toronto, you're right that we didn't talk about this at the last executive session, because I think that was before anyone went out on leave, if I'm not mistaken.
Absolutely was not discussed one bit at executive session.
I was
We
Incorrect.
could roll that tape. Not to sound snarky, but we could roll that tape and it was not discussed.
You're right. It was incorrect, but there was written statements and I just found it. So
Okay, so now I'm gonna go back to Counselor Golub and, oh, I'm sorry. Mayor, were you trying to answer the question that,
Yes, I was. Thank you.
did Danny wrap it up for you, or did you have something to add?
No, no. I just wanted to state that I believe it was approximately May 27th or towards the end of May, I held a press conference. And that press conference clearly stated why both police officers were placed on administrative leave in the beginning. It was printed in the newspaper. I have the document, which I suspect is the document that Chief Letourneau has located. It was in the newspaper, and it also stated that the other employee was brought back for staffing purposes before the chief. Both of them were out on administrative leave regarding this investigation only. In those statements, I make it very clear that it is a separate issue from the verdict. The previous executive session was, and Councilor Trunzo is accurate, it was to discuss with you again. Please understand, I value your positions and respect your positions as counselors and want to share information with you. But the situation necessitates that it be done in confidential meetings. It's just a fact. It keeps us all out of trouble to do that. So it is an executive session regarding the reason why he went out, both officers went out on paid administrative leave. It is a personnel matter for both of them. I do not have to be speaking to any of you on this, but out of respect and out of courtesy, I felt that it was important to share this information with you. And I think we are now an hour into this. If you continue and wish to continue to pursue this line of questioning, it's your time. We're here. Clifford and Kenny is here. Chief Haig is here. He has both Lenny Keston and his personal lawyer here. This is what this meeting is being called for, to share this report with regard to your police chief and his employment status and the results of the investigation, which is very clear. If you want to continue down this line, I can't stop you. I don't even intend to stop you, but I think there's more productive use of your time.
Okay, next.
Not about the verdict. You know what's going to happen. That has been made clear, and that was made clear in the last executive session. There is a motion for a new trial. That motion for a new trial
That is
has not
outside
been
of this
adjudicated.
executive session and should not be discussed.
Yes, point of
Thank
order.
you, Clerk Scott. So I understand people are really frustrated and people are feeling very emotional about this. So I'm just gonna remind everybody, to direct questions to me. We're not gonna have a lot of back and forth, and I don't want counselors interrupting each other. Next I had Counselor Golub, then Counselor Lapiansky, and then I'm gonna go to Counselor Healy because he hasn't spoken yet, then back to Counselor Ricketts.
So I hear the invitation to keep this short, but and as someone who wants to be with my kid later, I get that, but I believe this is worth all of our time, and forgive anyone who disagrees. But I'm glad that we have this opportunity to have this conversation. And I'm speaking, for those of you who don't know, as a counselor who was appointed after the last executive session. So I'm speaking both with the perspective of someone who was not in those meetings. And I have a couple of questions and a couple of comments. I think that I also had a migraine earlier today, so my speech gets slow, so forgive me for that. But I think that there was a confusion because initially the meeting was presented as being about the investigation, and it's about more than that. And I think that's part of where the confusion stemmed from. And also there has been confusion, no matter where it has been written or not written, about the reason that Chief Haig has been on leave. And I can see that from my perspective, the public, I understand. I get, like Marianne was saying, I get the complexity of this. And I get that there's certain things you can't talk about publicly. I totally respect that. And I'm flabbergasted, and I don't want to be flabbergasted. Chief Haig and I don't want to be having to say the things that I've said. I've really appreciated our interactions. And I wish that we weren't here. And as the public watching this, the most important thing, and as a public having watched the deliberations of the council session around the budget, and knowing that every single person, except for Jasper and Councillor Jasper and Councillor Jarvis, everyone voted to try to create a sense of accountability. If this is the reason why Chief Haig is reinstated, then the sense of accountability and public trust is, I believe and worried, will be even further damaged by this. And in addition to that, there's things that have come to my awareness that I have specific questions about before we go into the report. One is that, and this is to the attorneys, I believe this would be to Attorney Keston, maybe to another person, so you all can choose who you direct this to. But I'm wondering if I was made aware that that the investigator was a recommendation of Butch Hawkins, who is the my brain, sorry, the former father-in-law of the chief of police. Is there awareness of that here, or what is your awareness of this?
Can I just say something as a sort of not really participant in the selection? I can tell you that I do municipal work. I represent cities and towns all over the state. And there's certain firms that are known to all of us as top shelf independent investigators. This Clifford and Kenny, Henry Williams, are known to everyone. So I've seen them work all over the state. This is not, they're not, that somebody's brother-in-law. I know from my perspective, when I think the mayor mentioned some names, she mentioned that name. From my perspective, I said them, they're really solid. I know them. They've done work all over cases I've been involved in, cases I've heard of. So that's who the firm is.
And I'll just step in as well. I mean, I've never met anyone involved in this investigation, completely independent. I have no prior knowledge about any of the events that led up to the investigation. And I came in from a completely independent standpoint. And thank you, Attorney Keston, for the kind words about the firm. Appreciate that.
Let's get to know you, Dan. The firm is great. And I can tell you, yeah, they did not. I know firsthand, actually, of how, what information they were given or what they knew, nothing. And as you can see in the report, I was one of the witnesses they interviewed to learn stuff. But it is really, I think it would be a real disservice for anyone to think that this was some sort of, because of the relationship. I don't know who first floated the name, that this in any way, shape, or form would influence them, or that they had any connection. I assure you that neither Mr. Williams, nor Mr. Clifford, nor Ms. Kenny, as far as I know, have any connection to Greenfield other than thinking it's a beautiful place.
Okay, so I hope that is all all true, and I realize what I said previous to that question stands alone. regardless of the answer to that question. And my other question, and please slap my wrist, Kathy, if this is out of turn, it may absolutely be, but this really concerns me. And if this is a venue to ask this question, I want to ask it. And this is specifically to Chief Haig. And again, I just want to say this is, I really appreciate our personal
Actually,
interaction.
can I have you pause for
Pause,
one
stop,
moment?
stop. Okay. Okay, yes, absolutely. I will stop. Sorry.
So before we moved on, we had counselors asking questions about like the procedures that we were going to follow tonight, and then we were going to get an overview. And I just want to make sure that everybody asked all those procedural questions first, and then we get the overview, and then we can start asking about the sort of the meat of the. It's okay. I got ahead of myself earlier when I was reading the agenda, so I don't blame you at all. We'll forgive each other.
The other one is more about meat, so I'm happy to wait if that's better. That
would be
your choice.
I would appreciate that. I have Counselor Lapansky, then Counselor Healy, and then Counselor Ricketts.
Can you hear me?
Yes.
So my question was not procedural, so I'm going to hold it.
Okay, thank you. Counselor Healy, I had you next.
Yeah, sorry, my voice is a bit raspy. I'm battling strep throat right now, but so the whole thing here, we entered this to discuss reputation, character, physical condition, mental health of a Greenfield employee, right? And the documents that were sent to us from Clifford and Kenny, the investigation, bullet item B, page 3, specifically references the lawsuit and the proceedings in the jury trial. And I'm just playing devil's advocate because I like to. Although the jury in the lawsuit ultimately found the defendants discriminated against Mr. Buchanan, the jury did not similarly find person A.
That
as
is
a
not
whistleblower.
within the scope of this
It is. It's
executive
right in the
session.
document, though.
It is
It's
in the document for information, but it is not to be discussed tonight.
I guess I'm confused then. What are we? It's in the document that we're supposed to be discussing. We're discussing the reputation of an individual that we're talking about here and reinstating their employment, and we haven't even gone back to trial yet. But I'm confused.
The scope of tonight's executive session, to try to nutshell it, is relating to Chief Haig and the case and the documentation that you received solely regarding Chief Haig, not about any other lawsuits, not about any other employees. It's strictly related to Chief Haig.
Yeah, and I think this is going to be challenging for folks because we say nothing happens in a vacuum, but according to open meeting law, we're supposed to discuss this in a vacuum. So we're going to help each other if someone steps out of bounds. But we're going to try our best not to. Does that make sense, Counselor Healy?
Yes, I still, from a legal standpoint, disagree, but.
No, I completely understand. It's very confusing, and I don't think we're supposed to be using the chat. So yes, it is very confusing, and it is hard to take this out of context, but we're just discussing the conversation that they had and then the investigation around that conversation. I know it makes it tough.
I'd like to get some sleep tonight, so let's just move on.
Okay, next I had Counselor Ricketts.
Oh, I think Council Lapiansky's speaking to you, but I don't know if you can hear him.
What?
I think, did Council Lapiansky?
Yeah, I was just wondering if I could get back on because now I do have a question about process.
Yes, he can go before me, yes.
Yes, go ahead.
I mean, I couldn't agree with Counselor Healy more. I think that there's sort of a background agenda to this meeting, which is governing what we're allowed to say more than open meeting law. I'm not sure that, and the lawyers that are saying what's legal and what's not are the lawyers that have a stake in this case. So it really seems one-sided, and I basically agree with Counselor Healy, and I don't think that the boundaries that were being given are legal boundaries. I think that they are practical boundaries for the purpose of giving the chief his job back.
So I'm not going to have anyone answer that. If you read open meeting law, it is very confusing, and there are things like this that do come up where you have to pretend that you're making that decision in a vacuum. I don't think any of the lawyers here are trying to finagle anything. I've read that section. It's very clear. And Clerk Scott has read it more often than I have and knows better than I do. And she's gonna help keep us on track.
You don't even know what's going to happen with the job yet, because you guys haven't gotten to the point where you hear from the attorneys or the investigators. I think the answers that some people have will become clear once we let the attorneys speak. We have 3 different attorney firms who don't work together, who both gave legal opinions on whether or not we could expand the scope to make it less confusing. It is open meeting law that makes this hard for us. It's not people trying to pull wool over people's eyes. That was out of line, and I'm sorry.
All right, so Counselor Ricketts, I'm sorry, I'm trying to read your mind here, but I think that you don't have procedural questions, right?
Oh, no, I do. I do want to, yes, I do want to say, Director Letourneau said a lot of it for me, is that I do think if we could just listen to everyone else who's been invited, we will more understand this. Because unfortunately, I have to say, I did watch the community and some counselors get a little bit of the information from the trial, and we didn't have all the documents yet, and people ran with that. And unfortunately, lots of things were said and done, and it was really difficult. We did it with no information, really, or we didn't have all the information. So now here we are again. We have the opportunity to get all the information. And so once again, I would like to hear it because I have read it, but I think it's better if I can hear it from counsel. I think we all have to stop trying to be a lawyer for one moment, let the lawyers speak, and then maybe we can ask questions afterwards if we're still then stuck. Or maybe we don't like it, but we're not here to say whether we like something, if we're in favor of it, we're not in favor of it. We're here just to hear the facts. And quite honestly, the mayor is correct, and I have no dog in this fight for anything, is that we could just be reading about this from a press release later. But we are getting to hear about it tonight. So that's exactly what I'd like to do, is hear about it, because we get to do that. Everyone else, once anything happens, will just read about it, and they weren't in the position we're in. So I would like to accept that power that we have right now to get the facts and to understand them, and then try to work through it from there. So thank you so much.
All right, thank you. Were there any questions before we get into the meat of the discussion here? Okay. So since the mayor had called this meeting, did you have an opinion on who is going to be presenting this information to us? Is it Attorney Williams? Did you want to announce to us your decision? I don't know how you wanted to run that.
President Gilmore, I think you're addressing me. Is that correct?
Yes, please.
Yes. That is why Daniel Williams is here. And I appreciate Councilor Ricketts' sentiments. It is important that you hear from him. You've had the report. I just do want to reiterate again, these are tangential issues, but the reasons for the paid administrative leave are around this investigation. And it is incumbent upon me to call for that investigation. With regard to Councilor Golub's question about where did Clifford and Kenny come from, understand, please, this is new to me. Nothing like this has ever happened to me. It's a first. I've had a lot of those in my tenure. So I have to go find a reputable firm to conduct an internal investigation.
that is independent versus having the police department do it, which would have been totally inappropriate. So I began asking various people. I do not recall asking Butch Hawkins at all. I believe I started with the internet, quite frankly, like everybody else does. I Googled it and came up with some names. And then I asked Attorney Keston, who was the attorney at the time. I ran several names by him, I think 3. There aren't many people who do this work. And he certainly recommended Clifford and Kenny. I do not recall asking anyone else. And I appreciate Attorney Keston's endorsement of Clifford and Kenny. They have been nothing but professional. And I trust that the information that they received under difficult circumstances, which you have in front of you in your report as to how difficult it is to conduct an investigation when one party is not willing to be forthcoming. So yes, I would be happy to hear myself from Clifford and Kenny, and I hope the counselors will understand that.
Okay, so we're going to pull this back into the investigation. Clerk Scott, did you want to say something, or are we all set?
I wanted to remind people to stick to the scope of the executive session.
Okay, thank you. Okay, so I'm going to ask Attorney Williams if he would regale us.
Sure. So thank you all for having me here today. I'm happy to answer any questions at the end. I'm just going to try to go over what the scope of our investigation was, who we talked to, what we did, what we found, and then I'll open it up to you all for questions. So just at the outset, the scope of this investigation, as we've discussed so far, it was really limited to the testimony that was provided during that underlying race discrimination lawsuit brought against the city and Chief Hague. It's also stemming out of a related conversation that happened outside of the courthouse. And, from the very get-go, I want to make it clear that there really were only 2 witnesses there for that conversation. As part of the investigation, I contacted each of the individuals who we believed had personal knowledge of either the testimony during the underlying civil lawsuit or during that conversation. And I personally interviewed each person who was willing to participate. But for a number of reasons, not everyone was willing to participate, and that is perfectly fine. Public employees do have rights, and we want to ensure that we follow their rights and adhere to them. I also reviewed a number of relevant documents, including the court filings that were available to me, a written statement by Chief Hague, and the department's rules and regulations. I do want to point out that one of the most significant aspects of the relevant testimony has been filed under seal by the court. So for that reason, we were unable to obtain any copy of any hearing transcript, specifically the portions of the testimony that are at issue in this investigation. So as a result, all of the findings that are contained in my report are based on the evidence that I was able to look at, to review, whether it be documents, statements, whatever it might be, as well as the witness testimony. So the people who were willing to speak with me were Attorney Keston, Attorney Erica Brody, Attorney Alexi Keston, and Chief Hague. So as you can imagine, we really could not get 2 sides of the story here. We could only get one. However, the major findings of the report are based on my credibility assessments. And just for your own background knowledge, I am very, very much trained to conduct investigations and make credibility determinations. I've interviewed dozens and dozens of people in all different types of investigations, and I'm required in each to make credibility determinations for each person. In some cases, I find people not to be credible, and others I find people to be very credible. Typically, my assessment is based on the consistency of the statements being made by the witness's testimony, and whether it's corroborated by other people in their statements or documents, the witness's willingness to just discuss or make admissions that might go against their own interests, and other general factors such as their demeanor, potential motives they have, and the overall accuracy of their recollection. When I was speaking with Chief Haig, I really want to stress that he made very, very consistent statements throughout the course of the hour-plus interview. Many of those statements were corroborated by the city's attorneys, Lenny Keston's team, and Chief Haig's own written statement. So there was a lot of information that was corroborated. There was really no inconsistencies that I could find. Chief Haig also presented with a very level-headed demeanor. While we were discussing some very sensitive personal matters that could have cast a very negative light on him, Chief Haig was very forthcoming, and he was willing to go into details of these very sensitive conversations. I also want to point out that of the evidence that we were able to review, none of it contradicted anything that Chief Haig said or any of the information that was provided to us. So overall, I found Chief Haig to be a very reliable, credible, and extremely transparent witness. He didn't try to beat around the bush. He was very direct, he was very open, and he answered every single one of my questions. In terms of the findings, they are contained in the report and in the executive summary, which at this point, it seems that you've all read. So I'm not going to, bore you and take up more time to go line by line, just going over what we had. So at this point, I do want to stress that these findings are based on the evidence that we were able to review and the witnesses we were able to speak with. And from all of that, there was no evidence that we could find that indicated Chief Haig violated city policy or violated any other law. There's also no evidence that he, excuse me, I'm sorry about that. And there's no evidence that he committed perjury. As I mentioned, the relevant testimony hearing transcript is under seal, so we are not able to actually access that document. If that were to become unsealed, that might lead to a different conversation where we could have different findings. However, we can't do that. I had to base my findings on what information was available to me. And my findings are that Chief Haig was very credible. There was no credible evidence that he violated any city policy, law, or committed perjury. So at this point, I'll open questions. But I do just want to remind you, as we've all been just, due to potential issues with employee privacy rights and the open meeting law, I may not be able to answer all of your questions, but I will do so to the very best of my ability.
Point of order. The
Yes, go
report
ahead.
does not say that there is no evidence of perjury. It says there is insufficient evidence.
I'm sorry, I misspoke. I apologize. So there was insufficient. The only evidence that we were able to come across was the statements of Chief Haig and Attorney Keston and his team, all of which were very consistent. And there was no indication that, at least to me, that there was any sufficient evidence that he committed any perjury. But again, I don't know what's in that hearing transcript, so that's why it's insufficient.
All right, thank you. Is that all we're doing as far as presenting information before counselors are allowed to ask questions, or is there more information that should be
Yeah.
shared before we
I think
get
just
into questions?
based on the conversation, the way it's gone so far during this session, it seems like everyone's pretty much either read the report or the summary. So I think it would be a better use of our time to actually address questions that you might have as they relate to Chief Hague and this report.
All right, I see Counselor DeSorger. I don't see anyone else raising their hand yet, but if you'd use your electronic hand, that would be helpful, because like I said, it slides you up to the front.
I didn't find it right away. My apologies. Thank you, Attorney Williams. What documents did you review?
So they are listed in the report itself on the first page and into the second page. I reviewed the city's equal employment opportunity policy, the police department rules and regulations, job descriptions for chief of police and other police positions, the city and Chief Hague's joint emergency motion for reconsideration to unseal this voir dire hearing, which is sealed, the opposition to that motion, the ultimate decision and order that was reached by the civil court judge, and Chief Hague's written statement to a district attorney concerning this matter as well.
Oh, where's my hand? May I follow up?
Yes, go ahead.
So I did read that. When you said you looked at some things, I thought maybe you had looked something in the court document. So you said you mentioned something about the voir dire. You mentioned that just now, didn't you?
Yes.
Okay. So the Attorney Cassidy filed a motion to get that released.
Yes, he did.
What day was that?
I believe, I don't have the date in front of me. Attorney Casson, I'm not sure if you have that date handy. I can pull it up if you just give me 1 second. I can pull up the document.
Attorney Keston, you are on mute.
At the suggestion of my family, I tried more than once to get this released. The other council opposed us.
And may I follow up? Did the judge make a decision on whether or not he would release that?
Yes, and the judge did not release it, so denied the motion.
And what was the reason why the judge denied that?
As I point out, counsel for the other parties opposed the release.
So essentially, the judge agreed with the opposing side.
But so it's just important that one side wanted it out, the other didn't. You can draw your own conclusions.
And who asked for it to be sealed?
I did originally because there was going to be, I knew that there were sensitive information allegations against the chief. So I thought it would be a bad idea to have it public. And then the chief, at the end, when all this came out, when all this began, the chief agreed that it should be released. And we told the judge, we were the ones who originally wanted it sealed for privacy, the chief's privacy. We said we want it out now, and the other side now fought it. So far successfully, but someday I'll get it.
And that's still in process, is it not?
Well, we're done with that part of it, getting the thing. What's in process is there's a motion. Those of you that are interested, there's a motion for new trial on our part. First, there was a motion filed by the other side because the judge reduced their fee request. They filed a motion to get that. That was denied. The fee request was reduced. And there's a motion by us for new trial and a motion to amend judgment. All this stuff is available in a public record on the court website. So any of you that want facts, go to the court website and you can get everything that's been filed in court is there.
So I think Clerk Scott is going to say that we're stepping out of bounds.
Yeah.
So the voir dire is important to this because that was the evidence that would have been available for, if we were, when we were talking about insufficient evidence, it's because that information was absent, hidden, what, I don't know what you would call that.
Yeah, so it's filed under seal. It's a protective order. As Attorney Keston was getting into, there is, potentially sensitive information, and for that reason, it would be under seal. But as far as we are concerned, yes, I was unable to view that, testimony, so I could only base my findings, my conclusions on what I could either ask Chief Haig about or look at in documents or whatever other records were available.
Okay, so I do have a very quick question. Clerk Scott, let me know if this is out of bounds, but I think it's safe. If this information becomes unsealed in the future, that would have no impact on what is decided today, correct?
As far as I'm concerned, it would not impact what we're discussing today. However, it would ultimately be the city's decision if they want to reopen an investigation or do something else based on whatever might come out down the line.
Okay, thank you. Councilor DeSort, did you have a follow-up or were you going to ask a new question?
I was going to ask a new question.
Okay, if you don't mind, I'm going to go to Councilor Elmer and then I'll come back because I'm starting to get people lining up. So Councilor Elmer, then Councilor Toronzo, and then if no one new wants to speak, I'll come back to you, Councilor DeSorger.
Yeah, this is a question for the lawyers. It's really just a definition. Voir dire, you've mentioned voir dire a couple times. When I've been in court cases, voir dire is when you ask the potential jurors to say who they are and what their background is. What is this thing that you're calling voir dire?
If I may,
you can go ahead.
If I may, yes, you're right. That's one version of the voir dire. The other version of a voir dire is if the judge wants to hear, the judge will have a hearing outside the presence of the jury. Sometimes it's to find out if an expert is qualified, or sometimes it's to make a decision on evidence. The judge may say, before I decide whether the jury hears this evidence, we will conduct a voir dire, that is a hearing outside of the presence of the jury, which is exactly what happened here.
Thank you.
So it's used in different ways. It's also pronounced in different ways. In the South, they call it voir dire.
Thanks. Okay, I have Councilor Toronzo. And then if no one comes back, then Councilor DeSorger.
Yeah, thanks. I was curious, and maybe I just overlooked this. I didn't see, when was the timeline of the investigation? Because, I mean, I see all the dates in the investigation referencing, what was said where and but was the investigation done, I guess most importantly to my question, was the investigation done before or after the other party was reinstated?
I'm not sure of the date when this other employee was reinstated, but so I can't answer that question.
All right, so when were I'm sure I could find that at some point, but what was the date range, if you would, of your investigation into the happenings of outside the courtroom stuff?
Sure. So I don't have the first date. I want to say it was very early June, possibly late May. I don't have the exact date handy. I could
Mayor,
find
do you
it.
have an answer? You have your hand up.
I do know that because of various vacations and so forth, it is summer. People do have a right to take time off. For various reasons, the investigation was stalled briefly, fairly briefly, from the time that I spoke with and created a contract with Clifford and Kinney and their ability to get started. And those dates could be provided if they were truly important. But as I recall, the investigation probably did, Councillor Tarunza, take place after the other party was reinstated. But as I mentioned before, there was a reason for that reinstatement, and that is very well documented.
All right, Attorney Keston.
I just want to answer the original question about the timing of our request, Chief Haig's request to have, and the City of Greenfield's request to have obtain a recording of the voir dire. The first motion was filed on May 6th. I believe I filed 3 more motions, even going up to trying to get the appeals court to act to overcome the objection of the other side to releasing this recording so we could have a proper investigation. May 6th was the first time, and then repeatedly after, if you look at the docket, you can see it all. But I believe there are 3 other motions with this judge, and I tried the appeals court too. Ran out of options.
Thank you. Are there any counselors who haven't had a chance to ask a question? All right, I'm going back to Counselor DeSwever.
So May 6th was the day that you got the verdict. And on that day, you requested this. You requested to release that. And also on that day, was it on that day that individual A and Chief Haig were put on administrative leave?
It was May 6th when it was May 6th, correct?
Both. Okay.
Both.
Attorney Williams.
Yep.
In your experience, if 2 people are accused of something, I don't know, anything, and they're going to be disciplined, in your experience, do both of them discipline the same way?
That's
until a verdict comes out.
That's tough. Every investigation is certainly unique. The circumstances surrounding every investigation is unique. Oftentimes there are just investigations even where people are not placed on administrative leave. So, in terms of the big picture, it depends. And, unfortunately that is a very lawyer answer, but that's probably the best answer I can give you at this point.
Did you have a follow-up?
I have a question for Deputy Chief Gordon.
I'm sorry, I was on mute. I was asking if Counselor DeSorger had a follow-up question to that.
I have a question for Deputy Chief Gordon.
What's your question?
I wanted to ask him I wanted to ask him about the administrative leave day, the day that happened.
The administrative leave of who, and can you just define that question a little bit better?
Yes, I think that must have been a very hard day for you, Deputy Chief Gordon. I can't imagine being in your spot, in your shoes that day. And thank you for being here very much. So probably that day you must have been told about this, that individual A and the chief, about how this was gonna go down, right? You were told that there was gonna be an administrative leave with, yes?
I'm sorry, I'm not entirely sure if this is within the scope of this executive session.
Okay.
I'm listening intently, but I'm not clear if it's within the scope.
President Gilmore.
Yeah, so it seems like, well, Counselor, just, I'm sorry, I can hear myself on her computer. Well, Counselor DeZorger is trying to figure out how she wants to word her question. I'm gonna move on. Actually, the mayor, I see that you raised your hand first. I'm gonna go to you and then Counselor Elmer.
Thank you, President Gilmore. I just want to assure Counselor DeSorger and the rest of the counselors that when it became clear that Acting Chief Gordon would become the acting chief, we were in consultation daily. And so whether or not he remembers that day, to me, is not relevant. We knew what needed to happen, and the investigation needed to begin, and he needed to be in place as soon as Chief Haig was put on leave. He is the deputy chief. He is the logical person to go forward.
Yeah, so I think that Clerk Scott is gonna tell us we're out of bounds. I'm getting good at this.
Sorry, folks.
All right, Counselor Elmer.
Yes, I'd like to make a comment about the scope of this investigation, and Clerk Scott is going to listen intently. I think the way it looks to me is that we have a procedural investigation here, and the result, and that's going down one track. But we also have a political problem in this city that has gone way down another track. And I think we're going to have trouble as a administration and as a council sorting that out.
So that is outside of the scope of this executive session.
Okay, thank you.
So I will extend an olive branch and I'll say that this is something that we can discuss in open session when we're not in executive session. But Counselor Elmer, if there was something that you were gonna say that was gonna bring it back into scope, I'm gonna give you the chance, because I don't want to cut anyone off.
Yeah, no, I appreciate it. I'm used to being cut off, and Kathy's about to do it. Okay, I've said what I wanted to say, and we can talk about this in public later, and we will.
Yeah, and I want to acknowledge how frustrating it is to, decide all this stuff in a vacuum, knowing that there is no vacuum. I have Counselor Toronto, then Counselor Bullock, then Counselor Forgy.
Thanks. I guess follow up, and I don't know if I'm going to get cut off here either, to be honest. To follow up as to why I was, not the only reason why, for posterity's sake, to know when this investigation started in a relative timeline to all of this unfolding, especially since the last executive session. It's not, please, nobody take any offense to this, but we heard and we read about how one party was a little more forthcoming with information. And the reason I asked why it was, or one of the reasons I asked why, or what the timeline was of when the investigation started, is thinking of a possible reason why one party would not want to, at that point, offer their opinion anymore, especially if they were already reinstated. it was for causation, I guess if that's the right word, for why the investigation might have seemed other than just the sealed records, might have seemed to be insufficient, have insufficient findings in one way or another. And I saw that, you know, both halves of this were considered essentially insufficient, one for lack of information and one for, well, also lack of information, but then making, because of that lack of information, more credible information, or seemingly credible information. So that's kind of, it was, I don't know, I guess just to put that out there as if I don't know where that stands as far as relevance goes, to be honest, but it was that was my thought as to, that was the nexus of, or the reason for my initial question as to when the investigation started. If it were just directly after the suspensions, while both parties were suspended, or if it didn't actually happen until one party was reinstated, it just might tip the scale a little bit in why one would want to be more forthcoming than the other. That's all I'm saying.
Danny, did you have an answer for him?
Yeah, I've been hunting all through my memos and timelines. I keep track of a lot of stuff just to find out. Sometime between, so I have a weekly briefing that I submit to the mayor as a confidential document, and it outlines things we talk about. And it's for reasons like this that I can usually find the dates. The mayor was on vacation for that council week, if you guys remember, in June, post verdict. Before she went on vacation, we had a discussion. It's not in my memo, but I know on 6/28, when she was back, on my memo to the mayor, there's documentation about the ongoing investigation. So the investigators either were already being summoned and vetted or had been hired by 6/28. I do not remember the date at which anybody came back to work from leave. I could probably find that, but I would have to go into a personnel document, and we're not discussing personnel matters of anybody except for GA. But I totally get that question. My memory is that this started very quickly after the verdict, while everyone was on paid administrative leave. And for various reasons, including lots of vacations, it didn't actually kick off until later in June.
All right, next I have Councilor Bullock, then Councilor Forgy, then Councilor DeSorger.
Yeah, I'm wondering how common it is. I guess this question, sorry, is it Mr. Williams? Is that Clifford and Kenny?
Yes, sorry.
Your name's not your name. But I'm wondering how common it is that a conclusion is drawn on an investigation without having any other party, especially the other party in the investigation, have any involvement in it whatsoever. Because just, I'll say this rather than have a follow-up to it, it seems rather biased that we would take an investigation that does not have equal party involvement.
So without going too far into, you know, outside the scope of this executive session, I will say, you know, I personally contacted everyone who may have relevant information to this investigation. Whether or not other people wanted to participate, you know, I can't control that. And there is such a thing known as the Carney rights, and it stems from case law where a public employee cannot be compelled to testify or participate in an investigation unless they receive transactional immunity for potential criminal allegations or criminality. So that's the best way I can try to answer that without really spilling over to violating any potential open meeting laws. Just generally that exists so certain employees can't assert their rights against self-incrimination, and that tends to happen pretty typically. So, you know, it's not, I wouldn't say it's uncommon where people don't participate and findings are made or we reach adverse findings against them. So it's fairly, I wouldn't say it's common, but it's not rare.
Thanks. I have another question too, I guess for all of the attorneys on the call, which is if you, hypothetically speaking, if you had a person in a situation, sort of a he said situation as we have here, would you advise your client to speak to an investigator who's investigating for the city that they're currently under lawsuit that will be appealed?
I will tell you that both people in this case. First, I want to divorce the verdict and everything else from the motion and everything else that happened. The incident which led to this happened long before the verdict. We determined that there should be nothing done, so there's a verdict. We would look back to do it in the middle of the trial. But the conversation with the DA and everything else happened long before the verdict. I can tell you this, as I tell every client, if you're telling the truth, you got nothing to hide. That's some other lawyers don't like to have their clients talking ever because, the Fifth Amendment, the danger of something. But to me, the fact finders, be they jurors, city councilors, selectmen, people on the street, usually appreciate it when somebody talks and wonder if somebody doesn't.
So you would advise a client to be a part of this investigation?
I have. I do, and I have. It is my practice. And I can give you a list of clients if you like that I've told. I had a client testify at a grand jury that was targeting him. Most criminal defense lawyers would never do that. And I told him, you tell the truth, you'll be fine. And he is fine. But that's me. I do understand the caution of some people who are afraid. All I can tell you is that in this situation, and remember something, you are here only because, as I understand, with the rules and everything else, because there was an investigation. Chief Hague was put on administrative leave, so the investigation was finished, and that is the only reason he was put on leave, and the other person too. That's the only reason. Nothing to do with the verdict. That's why you're here, just on that topic. Down the road, if the city council wishes to discuss other stuff, they're always free to do that. But in this situation, that's why this is narrow, because that's the only reason both of them were put on leave. No other reason.
And I'm not gonna offer an opinion on this. Just not appropriate given my role.
Thank you. I think the last thing I'll say on this topic is that I feel like there was something said earlier around that one party was forthcoming and one party wasn't, and draw your own conclusions on why that might be. And I just feel like as our role in understanding this investigation, drawing our own conclusions based on the evidence put before us isn't very smart for us to do. I think that we have to move forward with understanding that the context of why we're here tonight is, and it's becoming more clear to me that this was a step in the process to reinstate Chief Hague into his position, and that's it. There's nothing more. Like this document doesn't tell us anything else.
So from my perspective, like I said before, I can only make determinations as to credibility based on the information and evidence that I am actually able to review. So everything that is in the report, in the summary, those are based on what I found, without getting into any other discussion about anyone else. This conversation, as I understand it, is focused on Chief Hague and the findings that I made, and my credibility determinations, as I discussed earlier. Chief Hague was very credible. There's nothing that I could find that would sufficiently, disprove anything that he has said or otherwise cast a bad light on Chief Hague or tend to, disprove whatever he was saying. So ultimately, it was a credibility determination based on what was presented before me. And the results are, in the report, what it speaks to otherwise, you can read that. Because this is the executive session, we can't get into any other details that are not related to Chief Hague directly.
Yeah, I mean, I agree with you, and I believe that you made the best determination with the information that you had before you. And I think from my perspective, unless we have the unsealed document from the court, we can't really know what happened.
Thank
May I
you.
get
Next
on
I
the
have
list?
Counselor Forgy.
Thank you. Actually, Mary Ann has said a different way what I was going to ask. This is obviously Attorney Williams, a finding that Chief Hague is highly credible. That is in this regard to this particular issue. Is that correct? I just want to clarify that.
To this issue and this investigation, yes, Chief Hague, very credible.
Okay, the other piece that I wondered about too is in the conclusion, it said there was insufficient credible evidence to determine whether either party had committed perjury. And at the conclusion of the report, once again, it speaks to the fact that there was insufficient credible evidence once again. So I would like to know how one reconciles the two pieces. You do find an individual to be credible, but you find that there's insufficient evidence to make a conclusion either way in the case. So how do you reconcile this?
Sure. So I guess the best way to put it is that they're two separate issues. So whether or not someone is credible doesn't speak to whether or not something happened. In terms of assessing what has been provided to me, that's where the credibility determination comes in. And from what Chief Hague said to me, told me during our interview, all of the documents that I reviewed, the other witnesses I spoke with, there was no reason to question whether or not Chief Hague was being truthful, credible. I fully support that he is a credible witness and what he was telling me was truthful. In terms of the insufficient credible evidence to find that Chief Hague committed perjury, for example, I can't find that, even though I find that he is a very credible witness. There's really no additional corroborating evidence that isn't just hearsay. And in addition to that, we don't have the hearing transcript. So there's no way for me to look at the facts of what was said and evaluate it based on what was said during interviews, during the investigation. So for that reason, I couldn't make a finding. There's insufficient evidence to make that finding as to whether something occurred. The finding as to someone's credibility is separate. And, there was more information that I could use to determine whether or not Chief Hague was credible.
Thank you. Can I follow up, please?
Yes, go ahead.
Okay, so this is to my fellow counselors. At the beginning of remarks this evening, the mayor said that she wanted to give us as much information as she possibly can regarding the reinstatement of the chief, which is going to happen. So to my fellow counselors, I would say that this is an issue for the administrative side of government. This is not really about us. It's not about whether we approve or disapprove or don't have any opinion at all. It's basically a courtesy piece to us at this particular point. Thank you.
Thank you for the reminder. And like I said before, and I'm not trying to call you out, but direct everything to me because I know that people are going to get emotional and this, you know, if it gets ugly, I want to sort of keep it tamped down. Okay. Councilor Ricketts hasn't spoken yet on this in this part of the meeting, so I'm going to go to her, then Councilor DeStroger.
I haven't spoken in this part either.
Okay, so Councilor Ricketts, then Councilor Lapinski, then I'll return to Councilor DeStroger.
He may go first. It's fine.
Well, with that invitation, my question is, what is the purpose of the credibility determination, and how does that help us? How does that help us as decision makers, given that we're just here to listen?
So the credibility determination really speaks to whether or not I can believe what someone is telling me, you know, based on all of the evidence. And the credibility determination really establishes, you know, what information I'm being told, whether it's true, whether it's false, whether I have reason to think it might be false. You know, it really speaks to the overall picture of the information that I'm getting. As I said earlier, it is different from making a finding as to whether or not something happened. In this situation, Chief Haig, Attorney Keston, and his team were the only witnesses to speak with me. So for that reason,
Sure. All due respect, Attorney, my question was not what is a credibility determination. I know what it is. My question is, what was the purpose of doing one in this case?
so credibility determinations are important for every investigation. And for me to even make a finding, I need to base that on credible evidence. I need sufficient credible evidence to make any type of finding. And in order to get to that credibility, I need to make a determination whether or not the information I'm getting is true, false, whatever it might be. So for that, you know, it's in this case, I could only base my credibility determinations on what information was provided to me.
I see. And what is the value of presenting the credibility determination in the way that it's being presented? How does that help us as decision makers?
I'm not sure what you mean by the way it's being presented.
Well, you gave us a report, and now you're telling us about it.
Right.
Yeah, so if I may, I think that if the only source of information they had was somebody who didn't have all of their faculties, it's not information that we would rely on, and it's not information that they would write a report on. I think that's kind of the crux of this.
Okay, and just one other point. If an employee hypothetically doesn't participate in an investigation, as an investigator, I'm entitled to draw a negative inference for that reason. So that's something to really keep in mind as well. You know, if I look at the facts, Chief Haig fully participated and someone else might not have, that's a credibility determination for me.
Okay, so I have a question about that. And I'm sorry, I'm going to cut in front of my counselors. What about the power dynamic when you're talking about a person who's in a disagreement with their supervisor? I mean, if you came to me and asked me to blab about my boss, who signs my paychecks, I'm a union rep also. So, I mean, I have to sit with people who are afraid of talking about their supervisor. So I would like to know how that comes into it, because if you've got someone who's being supervised by the person they're complaining against, and you can make a negative inference based on them, not wanting to talk about it, that seems like classism.
I mean,
Not racism in this case, but I mean, you could draw some inferences there. right?
It's a matter of law. It's established in the state of Commonwealth. So, I am entitled to make that determination. There's case law on it, and I don't really want to go further down this road because I think it might run into some potential issues with the open meeting law.
Okay, so, but it's not unique to this investigation. It's not unique to it's common practice.
Yes, it is certainly common practice that if, an employee refuses to participate, we advise them that that's their decision. However, a negative inference can be drawn.
Okay, next I had Counselor Ricketts.
Okay, but I didn't ask for my.
Oh, I'm sorry. Go ahead.
Oh, I'm sorry, did you have a follow-up?
Well, I had another question.
Okay, I'm sorry, I didn't know.
No, that's fine. You were called on. It's definitely not your fault, Counselor Ricketts.
No, go ahead.
So my other question is, what? So you said you're entitled to draw a negative inference. Does that mean you're required to? Or that you can if you wish?
It's up to my judgment. So as the investigator, I'm entitled to make that judgment.
Would you not be entitled to make that kind of judgment even if someone participated?
No, if someone participated, then no, I would have to assess their credibility based on what they would be telling me.
Got it. I mean, I think the word entitled is doing a lot of work there. My final question is, given that according to your report, there is a 50% chance that the chief committed perjury, since you don't know who did, on what basis can you ignore that fact when you find him to be, and I say this with large quotation marks, credible?
So I'm just a little confused. Could you just restate that question for me? I'm a little confused.
So your report states that two witnesses contradicted each other on the stand and one of them therefore committed perjury. You don't know which one because there's insufficient evidence to determine that.
Correct.
That says that 50% chance that the one who committed perjury was the chief, since you have no way of knowing which one it was, and neither do I. But finding someone to be credible when there's a 50% chance that they committed perjury is hilarious. It contradicts itself. And I have to be honest with you, attorney, according to your own rules, I don't think you are credible.
Okay. Well, we're not here really to discuss
I'm going to move to Counselor Ricketts next.
Okay, thank you.
Then Counselor Gallo, can you remind me, have you spoken on the crux of the issue or just earlier when we were talking about procedures?
Yeah, I have not yet been on the crux of the issue.
Okay, Counselor Ricketts, then Counselor Gallo.
Okay, thank you, President, and thank you again to all the attorneys. And on behalf of the council, I just want to say I apologize for that last statement. I'm sorry that happened. But I just want to say that I do agree with Councilor Bullock and Councilor Forgy about the information that was given. So that's all that we have. And so that's it. We have the facts. And I want to thank the mayor for letting us be part of this. Once again, I'm stressing it only because I don't want to read things in the paper or have a lot of people knowing about things and talking about it. We're the last to know. So I totally respect this process tonight. And I'm glad that we do have this information. And thank you so much for all the work. And again, I apologize for that last statement. Thank you.
Thank you. I had Counselor Golub next, then Counselor Toronto, and then back to Counselor DeSorger.
Okay, yeah. So I thank you for coming back to me, Counselor Gilmore. I've had a question that I've been trying hard to make relevant, and I think that I've figured it out. And that is this whole discussion of credibility didn't take into account did not take into account the fact, sounds like, that Chief Haig was found guilty by a court of law for racial discrimination.
Point of order.
Okay, go ahead. And also that it recently came to my attention that Chief Haig has not been recertified by the Post Commission.
Is
And
outside the scope
okay.
of this executive session as well as any other litigation.
Okay. Let me just see if I have any follow-up to that.
I just want to say one clarifying point. I mean, my investigation, it had nothing, it stems from that underlying civil litigation, but it has nothing to do with whether or not those claims are substantiated. I didn't look into that claim. I didn't look into any of that. I only looked into what happened during the trial and outside of the courtroom, and that's it. I didn't make any opinion as to whether or not Chief Haig did certain things, didn't do certain things outside of the scope of my investigation.
Okay. I'll just say that I have found Chief Haig we've had good interactions, but public safety isn't going to be restored by this conversation for many reasons that are outside of the scope of this conversation. And I wish that I could speak to that, but I don't have a follow-up question.
I'm going to make sure that folks have a chance to speak to that in an open session, because there are some parts that our constituents do deserve to hear. And we're going to get more into how we discuss this outside of this session. Towards the end, we'll do a little bit of a debrief. Okay. Counselor, is it Counselor DeSorger's turn now?
Counselor Toronto.
Counselor Toronto, I thought he had spoken during this part. All right, go ahead, Mike.
Thanks. I appreciated the clarification and kind of what Attorney Williams, the reason that I was bringing up what I had said earlier was kind of saddled upon what you were saying was a negative inference is because you heard nothing, you heard radio silence, right? So that's something you can defer to is a negative inference, but it's not substantiated determination. Like you can't, it's right. Is that
right? I can make an inference, but
right.
And it's not just because of radio silence. It is because of a refusal, but I don't want to get into that because it toes that line. And
well, no, because I was noticing that those words were used in the determination. So I wasn't in any way refuting what you can or can't do, or I don't want to go down that entitlement road. That's not where I'm coming from. I'm coming from like to separate the two ideas is by, this is exactly the reason why I asked about the timeline, is you weren't able to make a substantiated determination against the party that didn't participate. You can make a negative inference because there was no participation, but that doesn't by default allow your determination to say that that person gets a negative, overall recommendation or what would, you know what I mean? Like, and I think that those sometimes those wordings can be confusing as to what we've talked about tonight, as to why the determination was made that the way that it was. And so when I was reading the summation at the end was essentially like, as I forget which counselor was pointing out the actual like last concluding sentences was, all in all, there was no determination of it was like unsatisfactory. I forget which word it was.
Insufficient.
Insufficient, right? Both were insufficient. Just because one is found sufficiently credible, it doesn't by default make the other one insufficiently because there was not enough information to make one match the other. It's, you can have a negative inference because you didn't have participation, but that doesn't by default make that person insufficiently credible. Is that correct?
That's a fair assessment. You know, every case is different, and you know, credibility is a big factor in determining what happened. You know, you can't, like you said, I can't look at someone who doesn't participate and say, all right, just because you didn't participate means everything the other person said was true. You know, at the end of the day, in this situation, I interviewed Chief Haig and 3 other witnesses, Attorney Keston and his team, who were all secondhand witnesses. So I was only able to speak with one person who had firsthand knowledge, and I can't make a finding either way about Chief Haig or anyone else.
Right. So the reason I was saying it was to echo kind of what Attorney Keston was saying earlier was there could be strategies in any case as to why you would or would not want to say something, and which is why I was bringing up the timeline of the investigation. Was there might have been a reason, depending on when it happened, on whether or not somebody would be more forthcoming, depending on whether it was a month earlier, a month later, when they were on suspension, after they were reinstated. Like, and so I get the gray area that gets involved in there. And so I didn't want it to be misconstrued that, which I think your findings totally said at the end was, though I find this person who I was able, from the information I got, this person was credible, it doesn't necessarily mean this person's not credible. It's
based on what I was able to look at. Correct. Yes.
All right, next I have Counselor Disorder, then Counselor Elmer, then Counselor Bullock.
So I kept hearing these same words, which in a way were kind of throwing shade. Not forthcoming, not cooperating, negative inference. Were you made aware that when 2 people were, I was trying to get at that by asking Deputy Chief Gordon, were you aware, Attorney Williams, that 2 individuals were placed on administrative leave in extremely different circumstances? That one of them was on house arrest, that turned in his car, and the other one, none of those circumstances. Were you made aware of the difference
This is
before?
outside the scope of this executive session.
No one was on house arrest.
This is outside the scope of this executive session.
Fine. I'm done, but I think I'm glad that I said that.
Okay, next I have Counselor Elmer, then Counselor Bullock, and then the mayor has her hand raised as well.
So just a timeline question. The conversation that you investigated happened on April 22nd. A week went by, another week, and then the jury verdict came out. And then the mayor launched the investigation. Have I got that right? I'll ask you the question, Attorney Williams. When were you given the assignment?
I can tell you when my first interviews were. The interviews with Chief Haig, Attorney Keston, and his team were the week of July 11th. So I was given the case before that. I believe it was early June, and then we had to do scheduling. We had to review the underlying documents, and that's, you know, it takes time. And to be quite honest with everyone, you know, investigations can take a very long time. We put this at the top of the priority list, and we got through this as quickly as we possibly could.
That's enough. I just wanted to get it straight.
I mean,
The
Attorney
total
Keston,
delay.
did you want to answer the question about the timeline? Because I know we discussed this in April. I mean,
The primary thing you should know is this: as soon as this conversation happened, there was first a conversation between myself and the other officer's lawyer, followed the next morning by a conversation between Chief Haig and the other officer. And as soon as we learned of that day, we started talking about what needed to be done now, because we considered it to be a quite serious issue. And so it was that day, the day after the conversation, that I brought the attention to the judge and to the first assistant district attorney. And we wanted to wait until the trial was over before doing anything else. And the moment the trial ended, as you saw, I requested the audio recording be unsealed, not even unsealed, so we could have it for the purpose of investigating what happened.
Okay, thank you.
That happened on, I think it was April 26th. That's the date you said of the verdict. That very day, my motion says, because why do we want it? Because the city wants to do an investigation. So that's when it all began.
The verdict was 2 weeks later.
May 6th.
Yeah.
It was May 6th that I filed the motion, whatever that day was. I don't have it in my head, but that day we wanted to, as soon as the verdict happened, I filed a motion. I began my efforts to get it for the very purpose so that the city of Greenfield could determine what happened, because in my opinion, it was very serious.
I think the day that you went to the district attorneys and had that meeting was the same day I got a parking ticket, because I was in court that day. I got a parking ticket in Northampton.
There you go.
It was April 26th, I think, 26th.
I do have a follow-up.
Oh, you're right. I want to clarify. She's exactly right. I went to the day in April 26th. The day of the verdict is when we filed the motion to on May 6th to get the recording for the investigation. But the investigation had been discussed between April 26th and May 6th. It just nobody wants to do, we chose not to do anything during the trial.
Just to put it on the table, the investigation, if it found more credibility with the chief than with the other person, would serve to cast some shade on that person and then on the verdict. Is that fair to say?
No one's casting shade at the fact.
No, it's not fair to say. The verdict was the verdict. And by the way, the verdict was against the other person, but let's not go there, outside the scope. But the verdict was the verdict. This is not anything having to do with the verdict. This has to do with a conversation, which, if the chief described it accurately, was very problematic from an ethical and legal point of view. And I tell you, I felt ethically obligated to report it. Whichever way it turned out. I wasn't there. You weren't there. Two people talked in a stairway. I wasn't there, which is why I said, okay, there's a problem. And we wanted to get to the bottom of it. The judge refused to do it. And we're still unable to get all the information. Someday we will. But that was a problem for the investigator. I got it. Because if you have to see what somebody exactly said to see if there's lying on the stand. They heard what we remembered people said, but there's an audio tape there. There is an audio tape which tells you exactly what they said on the stand, and we know from the chief what he recalls from the conversation. We do not know from the other party.
I have to follow up on that.
Good.
There's a tape recorder, recording of the conversation between these two people outside the courtroom?
No. The tape is of the testimony. Two things happened. They had a conversation outside. Then there was a voir dire. There was a testimony under oath, which was
President
taped.
Gilmore?
Yes, I think I know what you're going to say.
Really? Why?
Are you going to say that this is outside the scope?
I think we are. Yeah.
I think
We'll
And
follow
again,
up
I
later.
think that everyone has honorable intentions here, and it's really easy to
Absolutely.
drift.
I'm just trying to do my job.
Thank you.
And I'm hoping to have dinner sometime tonight.
I'm
Looks
hoping to
bleak.
go home.
Looks bleak for the 31st.
All right, Counselor Elmer, were you done or did you have a
I'm done.
follow-up?
I'm all set.
Okay, thank you. I have Counselor Bullock and then I have the mayor.
Yeah, I have another question, but this question just came as Attorney Keston was talking to me, and I don't know if I can ask Chief Hague directly questions. Am I allowed to do that?
You have to, technically, all of your questions are directed to me. If it's not fair, I feel like it's out of bounds, I'm gonna tell him not to answer or ask him not to answer. But for the most part, I'm letting people just answer.
There's a lot of attorneys here that can tell him not to answer too. If he,
Yeah.
he can answer. if
This
he
is
wants
lousy
to.
with lawyers.
So ask me what you want to ask the chief.
Yeah, Sheila, President Gilmore. I'm wondering why, and I had this thought when I first read the report on Monday morning. I'm wondering why the chief had that conversation, engaged in that conversation.
Yeah, I mean, Chief Hague, if you're willing to answer.
I had absolutely nothing to hide and I was telling the truth and I wanted it out there. I'm not the one opposing keeping that sealed.
I think the question was, Chief, to the conversation between you and the other officer.
Yes.
Why did you do it? I believe that was the question. Why did you participate? Why did you talk to the other officer in the stairway? How did that come?
I was approached by that officer and I asked my attorneys if I should speak to him. So I did.
I guess I'm wondering then why the attorneys thought it appropriate for these two parties who are in the middle of a court case to speak to each other without anyone else present.
What? Why I thought it was appropriate?
Yes.
The two of them worked together. They had to continue to work together after the trial. When the parties can always talk to each other. Lawyers cannot talk to another party that's represented. That's unethical. The parties can always talk. When I found out that the other officer wanted to talk to the chief, I thought, great, maybe they could, make peace.
I mean, they've been working together for 7 years while the court case hasn't been filed.
Yeah.
I was approached by that officer. I didn't approach that officer. That officer approached me.
And the chief I was asked through my team, I heard about that, and I said, if the chief wants to and he wants to, great, talk. That's what I thought was going to happen. Maybe a handshake. Let's get through it. It's not what happened.
Yeah, I mean, okay. I guess however you interpret the documents that we got put before us in the investigation, it could be interpreted that the attempt was to make a handshake and move forward. But I don't.
He asked, so you understand. So we're clear. I just read the story that came out, which seems to indicate otherwise. No, it was not. There was not an approach by Chief Hague or our team. The approach was by the other officer to Chief Hague privately.
I understand that. Yeah.
Chief Hague said, "I'll check with my lawyers," and I said, "There's no prohibition, and I don't think it's a bad idea." It turned out to be not so great, didn't it?
Yeah, so I guess my other questions that I initially had to come back to were, and maybe this is about timeliness. My first one is, my understanding is that this is the procedural piece in order to that's a part of maybe the chief's contract, or I don't know if it's state law or however it works, in order to bring the chief back into service. And so the second question I have is, when is he coming back? And is there other, courtesy information that we need to know about that, since that seems to be really all that's relevant?
So if you check your inbox, I believe the press release is there now.
I think the mayor had her hand up. You're muted, Mayor.
It's online.
I think that it might be time for me to speak, President Gilmore.
Yes, go ahead.
If you will allow me to do so. So, and this is in no
way an attempt to wrap this up, but we may be getting to that point. As I said in the beginning, you have this information as a courtesy. At the end of the day, it is a personnel matter that is handled by the mayor and the chief of police and the other individual. What the bottom line of this report is the conclusion is that there is currently no reason to keep Chief Haig on leave at this time. And as mayor, I have a responsibility to have the city of Greenfield protected by a fully functioning police department. And to do that, we need a police chief, a deputy police chief, both of whom are good and credible employees. And we need a full complement of command staff. And I think that has been abundantly clear throughout this period. So I think the people of Greenfield, the residents of Greenfield, want to know that they have a fully functioning police department. There is, in my opinion and in my judgment, no reason to keep Police Chief Haig on paid administrative leave at this time. And he will be reinstated as of tomorrow.
All right, are there any questions from any other counselors? Counselor Toronto?
I don't want to get flagged on this one, but I just want to say this is like a completely uncouth way of going about it, is to put out a, I understand that you want to say that this is by the graces of you that we're allowed this information, but to put out a press release while we're in the middle of an executive session, I just think is dirty pool. I just want to make that known.
I just want to second it. Like, I came in here with all good intentions, believing we would get information, but like, for lack of a better word, like, I'm pissed.
The information had to come out at a certain point in time. I'm not the one who conducted this discussion. It is the counselors, and the timing is what it is. The outcome is the fact of the matter. My decision to be able to reinstate the police chief. And I was giving you this information, as I said, as a courtesy. And as I said again, I'm not the one who belabored the point of the previous discussion for an hour prior to getting to the report.
We
You
thought
did
we would
not.
be done.
You did not. It's disingenuous in nature to do that, is all I'm saying. Like, we were asking procedural questions, and that's all that was. It wasn't to belabor the point. This is a discussion that's supposed to happen while people are trying to understand what the cloak and dagger kind of information we get at the 11th hour all the time. We get it at 4 o'clock before a 6 o'clock meeting all the time, and it's ridiculous.
You have had this
Conversation
information
is
since
outside the scope of this executive
4
session.
hours.
And you have had this information since Monday, 48 hours. That is what the law
The rest of
requires.
the information was at 12:50
This
something today.
conversation is
Okay.
outside. the
So,
scope of the
Counselor
executive
Toronto,
session.
we are
Done.
going to have a chance to talk about this in open session because now it's public knowledge.
Fine.
We can talk about this. I don't want to cut you off, but I do have to keep it within the scope because otherwise people will abuse, executive session to just have private conversations.
I understand. My apologies.
At the,
I know,
at the-
no, I know you mean well.
The
Counselor
7:30
Elmer.
release of the press release was timed with respect, was timed in the hope and the belief that we'd be finished with this meeting. We did want to conclude the meeting before it went out. The communications director and I had long conversations about when to do it. I thought
So
we'd be done by
this
7:30.
conversation is outside the scope of this executive session. Counselors Elmer and Forgy have their hand up. President Gilmore.
Yes, Counselor Elmer first, then Counselor Forgy.
President
Be
Gilmore,
careful, guys.
would you entertain a motion to adjourn?
No, So before,
Not yet.
President Gilmore, may I?
Second.
Actually, could we hear from Counselor Forgy first? Because I was wondering if she had a question relevant to this.
No, I don't have a question. I wanted to adjourn.
Before we adjourn, I need to
Point
have
of order.
Kathy.
A motion to
We have
adjourn.
No. We have another matter that we have to handle before we adjourn. Kathy
Before
was asking for me to solicit opinions from council about the release of this information after the matter has concluded.
We need to solicit the opinion of the attorneys in attendance regarding the release of the executive.
Hold on. This is to make this information public. Do we want this information to be public?
Yes.
Then hear me out. Kathy, would you please word it the way it's supposed to be worded?
We need to solicit the opinions of the attorneys attending regarding the release of the executive session material after the matter has concluded. If any of the attorneys have objection, or if Chief Haig has an objection to this executive session being made public upon conclusion of the items, please say so.
I don't think it's fair to ask him or us to answer that tonight. You'll have an answer tomorrow.
Okay, if folks would rather answer outside of the meeting, I think that is still, I think there's still a procedure for that, right?
There is.
Tomorrow?
We'll revisit it tomorrow.
The attorneys and Chief Haig can let the mayor know. And if that would be allowed to be sent down to me, so that we could know if we would release the executive session minutes when they are complete, that would be appreciated.
Are you talking about the minutes or the recording or what?
I'm talking about the agenda, the backup, the minutes, the recording, all of the executive session documentation.
And to clarify, that would be with employee A's name redacted, not the original document that we saw.
Can you give us an answer in 24 hours?
You'll have to ask Mr. Joyce, Attorney Joyce, who has so far been sitting like a sphinx.
He's muted.
Happily so.
Sure, we can get you an answer within 24 hours. Once I have a chance to confer with the chief.
Thank you. I see that the mayor has her hand up and Councilor DeSorger. And then Councilor Bullock. Oh, okay.
I move to adjourn.
Do I have a second?
I forgot to lower my hand from the previous statement. My apologies, President Gilmore.
Oh, it's no problem.
Can I ask who seconded the motion, please?
Councilor Healy.
Oh, couple people.
We need to roll call out. Councilor Golub,
Yes. Or here, roll call here.
roll call out of executive session, yes or no?
Yes.
Councilor Gallup, thank you. Councilor DeSorger,
Yes.
Councilor Bullock,
Yes.
President Gilmore,
Yes.
Councilor Lapinski,
He's
Councilor
muted.
Lapinski, you are muted. I will come back to him. Councilor Healy,
Yes.
Councilor Elmer,
Yes.
Councilor Forgy,
Yes.
Councilor Ricketts. You are muted. Councilor Ricketts. Councilor Ricketts is still muted. I will come back to her. Councilor Toronzo,
Yes.
Councilor Lapinski,
Forgive me, I was away from the phone for a second. What are we voting on?
Yes.
Motion to adjourn.
We're voting
Yes.
on a motion to adjourn or a motion to leave executive session?
A motion to adjourn and leave executive session.
They are one and the same motion. That is what I did not understand. I vote yes.
Counselor Ricketts,
Yes.
motion passes unanimously. The meeting is concluded at 8:40 p.m.
Thank you,
All
everyone.
right, have a great night, folks.
Thank you,
And
counselors.
I will be seeing you soon.